Okay, so Columbia University just agreed to pay 21 million in a settlement with the EEOC over claims of anti-Semitism on its campus. Now, this has been one of the largest public EEOC settlements in almost 20 years. But here's the thing, it's not just about Columbia University. This can impact your workplace too, because guess what? It is a signal of where the EEOC is focusing their attention. Now, the EEOC has already said that they are cracking down on religious discrimination. And employers everywhere, whether you're a small nonprofit, a mid sized company, a Fortune 500, it doesn't matter. You need to pay attention. So, in today's video, I'm going to break down exactly what happened, why it's important, and then give you a step by step playbook to protect your organization from ending up in the headlines like Columbia. All right, so let's get started. Now, here's the nutshell version. The EEOC investigated Columbia University after Jewish employees alleged that they faced a hostile work environment following the October 7th Hamas attacks. The claims included harassment based on religion, national origin, and race. And so rather than fight this out for years, Columbia went ahead and agreed to settle. And they'll end up paying $21 million into a claims fund just for affected employees. Now, on top of that, through a broader agreement with the federal government, Columbia also is going to face a $200 million fine and compliance monitoring. So the EEOC has made this clear. Anti-Semitism and religious harassment are priorities. Now, why is this important? At a high level, Title VII of the Civil Rights Act essentially makes it unlawful for employers to discriminate against employees or applicants based on their race, color, religion, sex, or national origin. And that protection doesn't just cover hiring and firing decisions, it also applies to every aspect of employment. So, think pay, promotions, training opportunities, and yes, protection from harassment. Now, harassment becomes illegal under Title VII when it is so frequent or severe that it creates a hostile or offensive work environment, or if it interferes with someone's ability to do their job. So, what does this look like in practice? This could be things like slurs or derogatory remarks around someone's religion or ethnicity. There could be threats, graffiti, vandalism, targeting an employee's faith or identity. Also, think about like blocking access to offices, workspaces, even classrooms in the university setting. It could also include things like slogans, disruptive protests, or things that prevent people from working safely. So, in other words, Title VII isn't just about protecting people on paper. It's about really ensuring that employees can actually show up and do their jobs without fear of harassment, along with discrimination. And I think it's also important to mention that the EEOC's focus isn't limited to Ivy League schools or just high profile employers. Any organization with employees are expected to provide a workplace free from harassment and discrimination. If your employees can't do their job safely and without interference because of their religion, ethnicity, or even national origin, your organization can face the same kinds of claims that we're seeing here in this Columbia University case. So, what can you do about it? One of the things that I love talking about is giving leaders and HR professionals some practical advice on how they can minimize these risks. So, I have a few ideas that I'd like you to think about, like a compliance checklist. So, the first one is to really look at your commitment to respect and safety in the workplace. So, you as the CEO or leader in your organization truly need to set the tone. There should be a clear message that harassment is not tolerated in the workplace. So every concern should be taken seriously and addressed promptly. This isn't just about writing another policy that sits in the handbook. Employees need to hear directly from leadership that any type of harassment will not be tolerated. Think of this like seatbelts. Now, we all know that cards come with them, right? But the reminders from commercials, from your parents, or even that little beeping noise that you get when you forget to buckle up, that reminds people that, hey, this is serious And this is a rule. Remember to follow it. That is what I'm talking about here. We need to do more than just write policies. There needs to be a consistent conversation or discussion around the importance that the organization places on maintaining a safe and respectful workplace environment, which includes talking about harassment and discrimination prevention in the workplace. Now, the next thing that I think you should do is take a look at your current policies. If you're watching this and you don't know whether your policies even mention religion or shared ancestry, then this is your red flag. Remember, policies need to be specific. Vague language like, we don't tolerate harassment is not going to cut it. You have to be crystal clear. Religion, ethnicity, ancestry, these things are protected along with the other areas of Title VII as well. But when it comes to things like demonstrations or protests, make sure that your rules are neutral and enforceable so that you're protecting both free expression and workplace safety. Now, the third thing I want to mention is to make sure that you update any complaint intake forms that you may have. You want to review these forms and ensure that they specifically capture things like religious and ethnic harassment. Now, the goal here is essentially just to make sure that you have the right information that you can provide to HR upfront so that nothing actually slips through the cracks. Then I would also say create or evaluate an incident response plan. If someone reports harassment or if an employee can't get access to their workplace because of some activity, you can't wait weeks to take action. Every organization should have an incident response plan that outlines what happens the same day or the very next business day. And that means HR, security, legal, all needs to be working together so that the issue can be addressed quickly and consistently and in compliance with the law. This leads me to my next tip, which is to train your managers. Most managers don't know what to do when an employee brings them this type of concern. It may not show up as someone saying, oh, this person used an out slur, right? Maybe it's more likely to be a repeated microaggression or a team chat that turns hostile, or even employees saying that they don't feel safe getting into the building or accessing the workplace because of things like protests. When managers dismiss these kinds of issues, it not only breaks down the trust, but the liability grows. And that's why you need to make sure that you train your managers not just on the policy, but how to respond in the moment, what language to use, how to document the facts, so that HR can step in quickly and help support the managers and the employee in that particular situation. You also got to think about religious accommodations. Now, not every issue is going to be harassment. It could just be an accommodation request. So, create a simple guide for managers that explains how to handle those requests for things like maybe schedule changes, maybe prayer breaks, maybe even religious attire. The goal is to ensure that managers know when to escalate something to HR instead of just shutting it down or handling it inconsistently based on who they're working with. And I could not leave you all without saying, remember to document everything. I know that sometimes this feels like just extra work that you have to try to document all these things. But the reason that we advise this is because good documentation is going to be your safety net. Record every step. You want to talk about what the complaint was, what evidence was collected, were there interviews, what was said, what are the findings, what is the action that's being taken as a result of those findings, and then the follow up. Because remember, if it's not documented, it never happened. And unfortunately, that gap can make the difference between demonstrating compliance and facing liability. So here's the thing, the Columbia case was a wake up call. $21 million dollars is a big number, but the bigger lesson is that these situations are preventable if leaders take harassment seriously, respond quickly, and set clear expectations. So here is my question for you. If the EEOC knocked on your door tomorrow, could you show them that you've taken steps to prevent religious harassment in your workplace? If your answer is no, now is the time to start. My name is Latisha Newby. I'm an attorney, HR executive and the founder of Cultivate HR Consulting. And we help organizations like yours not only stay compliant with the law, but also build workplaces where people feel safe, respected, and able to thrive. If you are a leader watching this and thinking, we might need some help tightening up our policies, training our managers, or even responding better to these kinds of incidents, then I think it's time that we chat. You don't have to wait until you're staring down at a $21 million settlement to get this right. You can be proactive. Check the link out in my bio to connect with me. And if you like this video, please don't forget to hit that like button and subscribe so you don't miss future videos where I break down real legal cases and turn them into actionable steps for HR and leadership.